Debbie Gross. I'm the CEO of Pennsylvanians for Modern Courts. Welcome to tonight's presentation on family court in Allegheny County. I hope that you will bear with us. This is a new experience for us in that we are doing it hybrid. So we are in person at Bethel Park Library, and we are also on Zoom. So because of the pandemic, we had been all by virtual and on Zoom, and now we are trying hybrid. So hopefully this will work. We had a similar program this week at the Carnegie Library, and we were somewhat successful, 90%. So again, thank you, and thank you to the Bethel Park Library and Monroeville Libraries for joining us in our PMC Shares programs. A special thanks to Corey Little of the Monroeville Public Library and Rob Batchelder of the Bethel Park Library. PMC is an organization that is over 30 years old. We were established as a result of a crisis, I will say, in the confidence in the judiciary. We have expanded our mission and our programming to make sure that there's access to justice. We advocate on behalf of fair courts, and we have a number of community educational programming to help individuals understand the courts and feel comfortable when they enter the courts. I want to thank Judge Nicola Henry Taylor and Morgan, oh my goodness, Benekovic, sorry Morgan.
That's good. That is good.
For joining us. So I wanted to thank Judge Nicola Henry Taylor for joining us. She's a member of was a member of PMC's board and has helped us with many programs in the past. She's one of 4 African-American judges that was elected to the Allegheny Court of Common Pleas in November. It was a very important, I'll say, event in Allegheny Court Common Pleas history. I also want to thank Morgan for joining us. Morgan is at Pollock Begg. She has a focus on family law, and I'm going to pass the program off to both of you, so thank you both.
Thank you. Thank you so much for inviting us, Debbie, and for that wonderful introduction about the great work that PMC does. We're going to start with the court basics. In Pennsylvania, the court is basically set up in a triangle. The top, many of you have heard of the Supreme Court, especially with some interesting cases that have come down recently, but we also have an intermediate court where we have the Superior Court and the Commonwealth Court where people may appeal from the Court of Common Pleas, and that's where Morgan and I do most of our work. I'm a family adult judge, and we'll talk a little bit more later about the different areas that family court handles. But the Court of Common Pleas does very important work. We also have magisterial district judges in Pennsylvania. In Allegheny County, we have, and all other counties, we have magisterial district judges. But in Philadelphia, they have a separate system, municipal court, where they do hear some higher level matters that are criminal matters. One thing that starts in magisterial court are PFAs and some landlord-tenant matters and some other type of matters that may eventually get to the Court of Common Pleas if there is an appeal taken. So I'm going to talk to you a little bit about, in Allegheny County, the Court of Common Pleas, the trial level that I talked about, we have different divisions, and for those of you who like diversity, Allegheny County is doing well. We have administrative judges, and at this current time, our president judge is Kim Berkeley Clark, and our civil, where you hear torts like car accidents and slip and falls and contract disputes, those matters are in civil division, and we have Judge Christine Ward. Judge Jill Rangos is the administrative judge for our criminal division. That's where you're going to see very serious criminal matters such as homicides and felony drug cases and misdemeanor matters. But we also have a lot of good treatment courts like mental health court and drug court and pride court for prostitution cases in criminal division. In family division, where Morgan and I do a lot of our work, that's where we have Judge Kim Eaton as our administrative judge. There are divorce matters, child support matters, we have juvenile matters, children's custody matters, and we'll get into all of what family division has to offer. Orphans Court is a little known court, and people don't talk about it a lot, but it does very important work. There might be administration of wills and estates. Civil mental health commitments are handled there. Guardianships, if you have an elderly family member or someone with a serious incapacitation that can't make their own decisions, there's sometimes some heated litigation that goes on, and those courts are very important. And Judge Larry Lawrence O'Toole is the administrative judge for that. I'm going to turn it over to Morgan to talk about some contacts in family division.
Yeah, so as the judge said, we will be focusing on family court today and family law matters. So the family court is located at 440 Ross Street, and that is technically the address for the adult section. Now, the juvenile section has an address of 550 Fifth Avenue, but not to be confusing, they are, in fact, the same building. There are two entrances to the building. One is on Ross Street, and the other one is on Fifth Avenue. You can enter either entrance for any of your court proceedings that you have. And in addition to that, if you do have a child support case in Allegheny County, there's a South Hills building where you could have a hearing, as well as a Penn Hills building. So make sure you pay attention to the address on any of the pleadings you receive.
And I just wanted to add, you can also file documents in the Allegheny building. So that's another place they may take you or have a support hearing. Yes. I didn't think of that. That's a great point, Morgan.
And so,
Court.
yes, so the family court basics. Family court is divided into two branches, the juvenile section and the adult section. So the juvenile section consists of cases with child dependency, delinquency, and termination of parental rights, matters like that. There's oftentimes CYF involvement in those sorts of cases. And then the adult section deals with child support, custody, divorce, other, aside from custody, things that deal with primarily adults. And Allegheny County has a great rule of one judge, one family. So if a judge hears a case involving a family, they will continue to preside over all matters in that case. So whether it starts out as a divorce and then there's later a child support matter or a custody matter, the same judge will hear all of the cases. And that is also true if it crosses over into the juvenile section and there were to be dependency or delinquency issues. So I think that that's unique and it's
Yes.
beneficial to families.
It really is, especially in a big county like Allegheny County. One thing I wanted to do, and Morgan and I are going to play this game because lawyers, we have all these acronyms. So Morgan said CYS. It's CYF now. So that stands for Children, Youth, and Families. So as we say those acronyms, we're going to try to explain to you. We use a lot of Latin terms, so we'll try our best to explain to you. And we do encourage you to consider getting a lawyer, even though it's good for you to learn. We will throughout tell you about resources where the Allegheny County Bar Association, there's neighborhood legal services. There are many resources where you can get some more information. So I'm going to talk to you about a little bit about how it's broken up in family section, and Morgan did hit on a lot of that. So with divorces, you may, within a divorce complaint, someone could even file for custody in the divorce complaint, but that may be handled by the same judge as Morgan explained. You may have at the same time that the custody case is going forward for adult cases, you may have a support for the spouse or for the child. There's juvenile cases that involve delinquency, and what delinquency is when a child is accused of violating a crime or something under the vehicle code, like driving under the influence, and they don't have their license yet. And there's this other thing called Act 53. And that's when, in Pennsylvania, there's a law that says if your child is addicted to drugs or alcohol and they're between the ages of 12 to 17, you can petition the family court to have them involuntarily committed. And so that is an avenue parents have and that they can utilize. It's not often utilized. There's what's now called, I think that's being changed from child's court, but there's some child-related matters. There might be some protection from abuse cases we handled, as we talked about child custody, the child protection, that's where we have, it's called dependency, where children, youth, and families are involved, and we'll touch on that again. And bypass cases is where a young lady who's under the age of 18 would like to get an abortion. However, she does not want her parents to know for whatever reasons, and she can petition the court. And there are wonderful agencies that help these young ladies, regardless of what your position is on this issue. There are the Women's Law Project and other resources for these young women. And as we talked about, we deal with different matters, which we kind of went over this, the subjects that were going to be covered in the conversation in the talk. Morgan's going to talk to you a little bit about divorce and some of the things, and it's very intricate. So we'll try to touch on things, but again, there are resources that can help you.
Yes. So we will start with the very basics of divorce. In Pennsylvania, there are two kinds of divorce. There is fault-based divorce, often referred to as 3301A, which is the statute, and then also no-fault divorce, often referred to as 3301C or 3301D. And fault and no fault are just labels that are attached to the processes, and they don't invalidate the way that you experienced your marriage at all. So we'll start with fault-based divorce. So obtaining a fault-based divorce is very complex, and it does require you to appear in front of a judge in court. And I know personally I've been practicing for 6 years, and I've never actually had to have a fault-based divorce. I don't know if you've had any in front of you yet.
It's interesting. I just received a case that they pled every single type of divorce possible in Pennsylvania. But as Morgan said, it is very unusual nowadays. There was a time where people would go to court, and like you see on TV, they'd put on evidence as to who cheated and who did whom wrong. But that is really not the focus now a lot of times in divorce cases. What are you focusing on in your cases and these divorce cases?
Yeah, so if a judge does grant you a fault-based divorce, it would be for something along the lines of you were abandoned without reasonable cause, or there was infidelity, your life or health were put at risk, you were married to somebody who was married to somebody else. Mm-hmm. So there are a couple reasons that are listed, but I would not recommend trying to get a fault-based divorce without an attorney. And it is important to note that if you do receive a fault-based divorce, it does not affect the division of property in your divorce. And I think a lot of people believe that if they are able to obtain a fault-based divorce because their spouse has done them wrong, that will benefit them when they are dividing the marital property, but it will not.
And we may get on to this later, but there is a point in support where fault may be at issue. But it's not something that's done very often, at least not in Allegheny County, and probably most of the counties. So go ahead, Morgan, on the no-fault divorce.
Yes, so for no-fault divorce, the first option is a 3301C. This is the kind of divorce you would get if you and your spouse both agree that you do want to be divorced. The timeline for this sort of divorce, there is a 90-day waiting period after you have served your spouse with a divorce complaint. So you would first file the complaint, then you have to serve it on your spouse, then you have to wait 90 days. After that 90 days, you are able to file an affidavit of consent. There is a note here that a conviction for a physical crime against a spouse is considered consent. So next, after the affidavit of consent are filed by both parties, the parties must either file a waiver of notice or a notice of intention to request entry of Section 3301C. Most people in my practice just file the waiver of notice, so there's not an additional waiting period. And then the process ends with filing a precipice to transmit record, which is just a document requesting that the court and the judge grant your divorce decree.
I will add, there is one lady in Allegheny County who works hard, and she's the divorce docket clerk. And if you do not have all of your ducks in a row, she will kick it back to you with this sheet that is dreaded to receive in the mail.
Yes.
So it is highly advised that you would get counsel. I know you can buy the forms at different stores, and I've had clients, and I don't know if this has happened to you in the past, come to me with a docket that's kind of all discombobulated. So this is an important area, the divorce is, to seek some assistance.
Yes, I agree.
Okay, so, and you're going to talk about the D now.
Yes, the second no-fault divorce option. And this is the route you would go if your spouse does not consent to a divorce. So the most important part of this is you do have to wait the applicable time period of separation. So that would be 1 year living separate and apart. If you separated on or after December 5th, of 2016. However, if you separated prior to that, there is a 2-year requirement for separation. I think at this point in 2022, it ends up being 1 year or
Right.
2 years, either way.
That's a good point.
And so if you are proceeding under 3301D, you have to complete an affidavit and the accompanying forms. There are a lot of forms when you file a 3301D divorce. You do have to serve them on the other party, and there are a few different waiting periods for this sort of divorce. You do have to file a certificate of service to prove that you did serve the forms on the other party, and then the process ends similarly with a precipice to transmit record. But your spouse does have the opportunity multiple times to object to the divorce being entered. So this is common with, I think, parties that are either one person just is simply not interested in getting the divorce, or they are fighting over generally property issues.
Right, and one thing to note is while some of the litigation is going on, you could agree on property settlement in a marriage settlement agreement, or you can end up going to the judge or a divorce hearing officer for equitable distribution, conciliation, and or trial or hearing. And so again, this is why the important notes that Morgan has here about getting a divorce attorney might be helpful, because it is very complex even for the attorneys that practice in this area.
Absolutely, especially as the judge said, if you are dealing with issues like alimony or splitting property, it's definitely best to have an attorney. I think we have a question.
Do we have a question? Do you want to come? Do you want? We'll repeat it. Okay.
It talks about how you have to be separate and apart. My understanding, if I'm wrong, Tommy, is that you can actually be in the same house, because it's so expensive now to have to go out and
Right.
get an apartment. Could you be in the same house
Oh,
and be separate?
her firm has had some interesting cases. I think I've observed that where you talk about it a little bit, Morgan, where people, what does that mean when you're in the same residence and you claim, one spouse might say we're living separate and apart, and another might say we're not because of the date of separation is at issue. So can you speak to that?
Yeah, that's a great question. So living separate and apart does not necessarily mean that you're not under the same roof. It has to do with leading separate lives and how you hold yourself out to your friends, family, the public. Are you still going to holiday parties together as a married couple, or are you doing things separately? The court might look at if you've separated your finances, if you've been intimate during this time. Those are all factors that the
And
court
believe
would
it or
look
not,
at.
those are topics in hearings under oath. And sometimes there's discussion about, well, who buys the food in the fridge and who's eating the food, and just a lot of very intimate details that happen in family division. And so, if you can resolve some of these issues without having to have a hearing, then your intimate details about those things about, how you're living your life may not have to come out on the record.
Yeah. And two other important points that I do want to point out before we move on is you do have to pay close attention to filing deadlines and waiting periods because you will encounter a lot of those. And if you file something too soon, you might not know that until the end when you're trying to file your precipice, and then you have to go back and do all of these things. So pay close attention to those. I always err on the side of caution of maybe waiting a couple days later than I think it's supposed to be.
Because if it's too soon and it wasn't within a certain time frame, some things, there's a couple of deadlines that Allegheny County does a little bit different than the statute. So
Yeah.
you need to, whoever is doing this needs to understand those nuances. One thing that I think is an important point in your notes is that if you don't resolve the economic issues before the divorce decree is granted, you can't raise them. Now, if you've resolved it in an order of court or a marriage settlement agreement, you could always go to court to enforce it. But let's say you had a house, and I've had that happen, and they never dealt with how the house, it was a marital property, how that's going to be handled. You can't then, after there's a divorce decree, come back and say, oh, by the way, let's figure this house out.
Yeah, exactly. Yeah, there's no splitting the house, and there's no getting support after the divorce is finalized. So if those are any issues that you are interested in pursuing, make sure you do that before you file any of the documents to finalize the divorce.
Very good point. So Morgan's going to touch on support at this point.
Yeah, so I think we will start with child support. Oh, wait, nope. We will start with all of the support. We'll start at the top.
Let me get there.
So there are multiple types of support under the umbrella term of support in Pennsylvania. There are two main types, which are child support and spousal support, or support of a spouse. And then under the support of a spouse, there are three separate types of support. There is spousal support, alimony pendente lite, and then just alimony.
Okay, so there goes one of those
Yes,
fancy
one of those
words.
Latin terms.
Yes. Can you just elaborate a little bit on what that means?
Yeah, I think it is on one of the slides, but I will say now, so alimony pendente lite is alimony pending the divorce. So this is the kind of support that you can receive between the time that the divorce complaint is filed until the finalization of the support. And I will say in Pennsylvania, oftentimes spousal support and alimony pendente lite are used interchangeably.
That's true. Let's see. And this slide does go into a little bit more of the detail of the spousal support pending the divorce.
Yeah, so again, three types. We'll start with spousal support. That is support that you can file for once you are separated. And again, separated does not necessarily mean not living in the same house, but if, say, you are in a house and your spouse is the high earner, the high wage earner in that house, and they've decided that they're no longer going to support you, they're not going to buy you groceries, they're not going to pay half of the bills because they want you to, that is a situation where it would be appropriate for you to file spousal support. As the second point says, that the higher earning spouse does have the duty to support the lower earning spouse. And I think Pennsylvania is unique in having spousal support. A lot of other jurisdictions do not have support that is guaranteed prior to the filing of a divorce complaint.
And the good thing is, it's not gender specific, and it relates to same sex. So it is about being a spouse and making sure that it's equitable. And in Pennsylvania, you hear things on TV about common law. We are equitable in Pennsylvania. Yes. So I'm trying to put people on equal footing pending the divorce, so that if a wife stayed home and took care of the children, for example, it could be a husband, and then the husband became a huge wage earner. He's this surgeon in a specific area, that she can litigate the divorce, and she can ask for an advance and those types of things. And so this is an example of how Pennsylvania will put the dependent spouse on an equal footing.
Yes. The second type of support that I will discuss is, again, alimony pendente lite. You will hear some people pronounce that differently, but that's how I learned to say it in law school. It's also known as APL. You might see that acronym occasionally. And that is available during the pendency of the divorce action. And the purpose is to provide support, again, to the lower earning spouse so that they can pay to defend themselves during the divorce litigation. Spousal support and APL both use a calculation or a formula to determine the amount that the lower earning spouse will receive. So there are other things that are factored into that, but generally it is just a formula that is used.
Right, and there are some cases where, and you may speak to that in this slide, where there's child support and there's spousal support, and so that affects how the calculation is done. So
Yeah.
if you want to talk a little bit about the child support.
Can I talk about alimony really
Yes,
quickly? Because I don't
sorry.
think I've touched on that yet.
Sorry about
and
that.
just that alimony is the type of support you would receive after your divorce is finalized. It's not guaranteed in Pennsylvania, and there are factors that if you want alimony, if you and your spouse don't agree on it, generally you would have to have a hearing in front of the judge, and there are factors.
So let's talk about some of the factors, because for people who have never been to court, not to get into great detail, but to just give them an idea of the fact of what was your education, do you have health issues? So, it's very fact specific to what
Yes.
your needs are and what your family's needs are.
Yeah, how long was your marriage? Things
Right,
like that. There are
right.
17 factors that are considered.
Right, and so that is, and then there are hearings on those issues, and the court has to make a determination.
Oh, we do have a question.
I just have a quick question as far as the different kinds of spousal support. Would the other spouse have to file, like specifically file, or could the court just throw out that alimony should be given to the other spouse? Like, is it something that has to be applied for during the support case if you have
Okay.
child support as well? Or could the court just grant alimony?
I
if
think,
no one's applied?
well, we have to repeat the question, but at this point, it sounds like you might be mixing two concepts, but I'll have Morgan repeat the question, and then,
Yeah, so is the question, when it comes to alimony, does the court bring that up, or is that something that you have to request?
That was kind of my question, is I'm currently in a support case right now. I did most of the filing, and my spouse chose to not do any filing. As far as with the alimony, if he didn't apply for it up to this point, and we're already getting an interim order, can he still apply for it at some point, or can the court, request that I should have to pay his support, or at something, at what point is the other spouse not able to apply anymore?
I think a part of it is we need to separate the two. So when you request alimony, that's in your divorce complaint. There's a count for alimony. For support, you go to in most counties, you will go to the domestic relations office, and there's a system called PACES. It's a statewide system, which it sounds like you're shaking your head, you're familiar with it. You would file for spousal support and or child support. But the alimony, as Morgan, and she can touch on this a little bit, that's more for after. But that's after the divorce is finalized, but it has to be addressed before the divorce decree. So it does become confusing, because while you can be doing both things during the pendency or the life of the case. So you may have filed a divorce complaint that has a count of alimony, and you may need to give your expenses and all that information to the court at some point. It's not an easy proposition to get alimony as people think. But then while you're pending the divorce, you may have spousal support. And then if the divorce complaint is filed, it may be called APL. But if you do not claim alimony in your complaint, unless somebody just voluntarily, I don't know if you would voluntarily agree to that, but there's no claim. The court does, it's not before the court.
Yeah, and I think, to make it short, you can't request alimony or any sort of support after the divorce is final.
Correct.
But child support until the child is either 18 or graduates from high school, whichever is later, at any point during that child's life,
Right.
support can be requested. Just child support, though. Did that answer your question?
Yeah.
Okay.
Yeah, you have to separate the two concepts.
Yeah.
Do you want to talk about the child support calculation?
Sure. So I think just basically to start, child support is based on the combined net income of the parents or the parties, and so that is your gross income minus some federal, state, local taxes, things like that. It's based on how many children you have and also the custody schedule. And then finally, after it is calculated, there are things that can be added in like childcare, health insurance premiums, and educational or extracurricular
So,
expenses.
From the perspective of a person that's living a real life, it's hard because child support is not an emotional area of the law. There are specific numeric guidelines, so it's a hard proposition when you counsel clients probably sometimes. It's not necessarily about feelings, it's about this is how the calculation comes about, this is your income. When you put it into the, we may be able to deviate certain things, but it's not, it's more of a numerical calculation than it is an emotional part of the law.
Yeah, I agree.
Anything you need to touch on there? You don't have to say all of that, it's up to you.
I think the only thing I would touch on is that there is a chart or a guideline chart in the statute or in the law, and you would be able to look at with your combined incomes based on the number of children you have. There is a specific amount of support that you should be receiving, and then like I spoke about in the previous slide, there are other things that may deviate or add on to that amount.
One thing I will also add is there are all these calculators online. They will not help you.
They are not accurate.
This is another place where having an attorney is helpful. But what I will say is if you need to do an intake, Allegheny County, you don't need an attorney just to file your support complaint. Allegheny County allows you to come in at certain hours and someone will get the information and complete it, and you could have a support complaint. But there's also an online tool through the Department of Human Resources, I forgot what it's called,
Yeah.
the Domestic Relations, and you can apply online as well if you are sophisticated in that way. Let's see, we did support calculation.
Yeah, and this is again just touching on additional expenses and child support. Childcare that is necessary for the other party to work. So, if you're looking for a babysitter because you want to go out on Saturday night, that is probably not going to be split or, taken into account for in child support. But after school programming and medical insurance are always added on top of the basic support amount. And this is in proportion to the party's income. So, the guideline calculation, if you are, you earn 75% of the combined net income and your spouse earns 25%, you will likely be paying at least 75% of these costs.
One thing I wanted to add is the unreimbursed medical costs. I don't think we
Yes.
have. So typically the person who is filing the complaint, they are usually responsible for $250 of out-of-pocket expenses, and then in the order, the court, and you can agree, or if you go to a hearing and the court finds, the rest of it would be split, and there's a process for making sure you provide documentation to the other party and do it via certified mail. So if this is something that's of interest to you in your situation, make sure that you follow the process so that if you need to go to court to enforce the fact that the other party is not contributing, that you've done what you need to do.
Yes.
So we're going to switch gears a little bit, and we're going to talk about child custody. Now, that is emotional, and it is very important to me. Children are precious, and unfortunately, sometimes in custody court, people fight about these children. So legal custody in Pennsylvania is one area of a type of custody, and that is the right for each parent to participate in major life decisions. And believe it or not, before COVID, when we had motions court, you would see parents fighting in motions court all the time. I want my child to go to this school. I want my child to go to have this religious ceremony. I want my child to play soccer or hockey. So this is an area where people do fight quite a bit. One thing in Pennsylvania, we do typically allow parents to share, although with COVID, it's been interesting. I've gotten a lot of COVID-related motions where one parent wants the child to get the COVID shot, the other one doesn't. And what the court typically does in that situation, whether it's COVID or mental health treatment, is you don't decide. The judge doesn't say, child, you can get COVID. What the judge says, typically after hearing from the doctor, the expert, which parent will have that small carve out of legal custody rights, and they would have sole legal custody in the area of making the decision to get the COVID shot or to get the mental health treatment. Have you had that experience at all?
Yes, I have. I have had, I just had a case like that recently, not in Allegheny County, but it came in through motions court, and it was actually ultimately denied because they wanted us to file a modification of the custody order
really?
instead of doing it as contempt to the shared custody.
Right.
Shared legal custody.
We'll
So
talk
it's
about that
very
later.
interesting.
Yeah, and it's evolving. We did not expect, COVID, we didn't plan for it. So the law's evolving. There's been some interesting articles written about how different jurisdictions, one jurisdiction, and this is in Pennsylvania, but it was in Chicago, the judge took away custody because a parent just would not follow any of the recommendations. Yes,
That's
so.
serious.
But it seems like Pennsylvania judges and local judges are listening to the expert and trying to make sure that the kid's best interest, children's best interests are being followed based on those recommendations. So what most people think about when they think about custody is the physical custody. And there are different areas, different types of physical custody. Primary physical custody is when you typically have more than 50% of the time. Partial custody, when you have less than 50%. So for example, one parent might have most of the time, and then the other parent might have every other weekend. That's a typical partial custody. Maybe they get a Wednesday dinner time. Shared custody is what really the courts seem to be moving towards. It doesn't have to be exact, and I know sometimes your clients might fight down to the death, but really just sharing the time, being flexible ultimately with each other, but technically it's 182 overnights per year, and that does come into play with support. So what I will say is, sometimes you see people fighting for custody for not the right reasons,
Yes.
because they don't want to pay a lot, they want that deviation, or they want more money. So, that's something that judges and lawyers keep an eye on. What is your motivation? Why can't you share?
Yeah.
Sometimes there's some underlying other issues, but that is a piece of it. Supervised custody is where there may be an issue with drug and alcohol, there's a safety concern, and there needs to be a supervisor. There are some organizations that you can pay to do this. We need more resources, so if somebody has an idea for a nonprofit, this is an area where there's a gap in services. Sometimes it's a family member. That can become tricky because if it's grandma or auntie and one parent doesn't get along with grandma or auntie, then we're in court for protection from abuse and other issues. But supervised custody is typically when something has come to the attention of the court, there's a safety concern, and we need to make sure that parents always are able to parent, but put in the guide rails to make sure the child's safe. Do you have anything to add about this?
The only thing I would add about supervised custody is I get a lot of clients coming in that immediately want supervised custody because they don't like the other parent,
Right.
or that parent's never been with the child by themselves, and
Right.
those aren't always reasons for supervised custody. Like the judge said, it needs to be a safety concern or a drug and alcohol concern, something
Right.
serious and something that you can show to the court. It can't just
Right.
be your word's not always enough to prove that.
You bring up a great point, because a lot of times in motions, we have a very robust motions practice in Allegheny County, and in the pandemic, the court has allowed people to file, some people to file things electronically, and we were getting all kinds of emergency motions saying, I have this dispute, it's a custody dispute, and I should have emergency primary custody, and just based on what they wrote there. And so what we were doing, a lot of us, is making sure we brought people in, whether it's, by virtually or having them come in, because that is a very serious thing to do, to limit a parent's parenting time. But yet we need to make sure the child's safe. So we're going to move on to procedural overview. Is that you, Morgan?
That is me.
Okay.
So this is, I don't want to say ever-changing, but has changed pretty significantly in the last few years. So the first step when you file custody in Allegheny County is you have to take the education class. It's called Generations. It used to be in person, but it is now done online, which I
That's
think
good.
makes most people happy.
Right.
Yeah, and it's more accessible to a lot of people because
Right.
sometimes, you were working and you would have to sacrifice, that day in work.
Right.
After you do the education seminar, you are scheduled for a mediation. The mediations, in my experience since COVID, have been completely by telephone. And it is only the parents or the people seeking custody of the child, they are the only ones that participate in that. There are no attorneys in mediation. So it's kind of a chance for them to sit down with the mediator and see if they can actually come to a resolution without having to involve the court and
Or
and
lawyers
attorneys.
being aggressive.
Yeah, exactly. If you're unable to come to an agreement in mediation, it kind of divides here. So if you do not have an underlying custody order already, then you will have an interim relief hearing scheduled. That's a 1-hour hearing with an officer, thank you, a hearing officer. And at that point, they're just looking to keep whatever schedule you have, so they want to maintain the status quo. So you may or may not have that hearing. After that, if you're seeking partial custody, you will have a hearing before a custody hearing officer. It's usually 1.5 hours, and the hearing officer will issue a recommendation. And then if you are seeking shared or primary custody, then you will have a conciliation, which is like a mediation, but with attorneys and a hearing officer, and you will try to, again, come to an agreement. If you're unable to do that at that point, you will then have a conciliation with the judge where you will again try to come to an agreement.
Right.
So the court gives you many chances to kind of work it out with the other party seeking custody, because at the end of the day, it's better for you to have a schedule that you have input into and not just one that the judge makes for you.
That is a great point. One thing I wanted to tell you about the mediation, and you may know this, is that the judges do not get those notes. It's very confidential.
Yes.
And if you leave there without an order of court and you get a memorandum of understanding, if you do not make it into an order of court, you do not have anything enforceable. Yes. So that's a step that I think a lot of pro se people miss. And pro se means self-represented. We do have a self-help center where there's some law students from Duquesne and Pitt Law that are in the Family Division Courthouse that may be able to help you with some of this. Now, when you go to, one thing I wanted to say too is you cannot appeal the interim custody order.
Correct.
And when you go to the conciliation with the domestic relations officer, they give us wonderful notes. So if you go to one of those, I would suggest you behave very kind and you are respectful, because the judge will find out if you were disrespectful or you raised issues that were not reasonable, you weren't not really engaging in the process. We will have very thorough notes of what occurred.
Yes, exactly. And if after an order is entered not by the judge, by one of the hearing officers, you can file exceptions to that.
Yes, good point.
And you can challenge at the findings of the hearing officer.
And that goes up to the judge. The exceptions goes to the
Yes.
judge. But if no one files, it becomes an order. It just automatically, by operation of how it's written, that it would become an order. So those are good points for the procedural aspects of this. So how do we decide custody? If we have to have a trial, and we have to make a decision. In Pennsylvania, there are factors similar to what Morgan told you about when we're looking at alimony. Some of these factors really overlap in Pennsylvania. There are about 18 of them. And I will note a nice addition to the statute is that it's gender neutral. And so all of these factors, we should not be favoring, mothers over fathers or fathers over mothers, or same-sex couples should be treated equally in the eyes of the law. So, but some of the examples, I'm not going to go through every one of them, but an example of where it overlaps is number 3, what each parent does to parent the child. And also, number 9, which party attends to the child's needs. That oftentimes when you see opinions from judges, they'll say this, see number, another number, because it really does overlap once they hear the testimony. One of the things that I find interesting is number 1, which party is most likely to permit continued contact between the child and the other party? When they're fighting in custody, that's a hard one because they, oftentimes parents do things and there's some factual evidence on the record of them withholding the child, or of them saying things about the case that they shouldn't have been discussing with the child. So that's similar in 8, who attempted to turn the child against the other parent. So one thing that judges have to do is after you hear all of this evidence, you need to make these findings on the record, and you also need to follow up with a written explanation of your findings. I have heard, but I don't know if this is true, that these might be, the legislature might consolidate this.
I've heard that.
You heard
as
that?
well,
Good.
yes.
Okay, so then that's, there's a possibility, because I do think that there's quite a bit of overlap. One of the things I want to touch on, because everyone asks this question, what's the magic age that a child can say what they want?
I was hoping you were going to touch on that.
What family law attorney have not heard that question? When they're 12, they're old enough, can they just say? So it's more nuanced than that. The well-reasoned preference of a child is important. What number is that? On
7.
7, yes. The preference of a child with the child's maturity and judgment under consideration. And I did say there's no magic age. So what a judge might do is they may appoint what's called a guardian ad litem, another fancy word. It can be an attorney in Pennsylvania or a social worker who is, they're tasked with trying to find out the best interest of the child. So the guardian ad litem may talk to the child about preference. There might be evidence in a custody evaluation that's done with all of the parties and getting collateral resources by someone who's PhD level about, and they may express a preference in that. Or I could do an in-camera interview, is another fancy word for I'm going to in chambers, typically without the parents or any attorneys present. There's a lot of nuance with that law, that's just changed. But ideally, I would want just me and the child. Even if there's a sibling group, I would prefer to do the siblings separately so we're not getting piling on and people trying to, there's a lot of dynamics in families. So, and talk to the child. The child does need to be competent. So if a child doesn't understand the difference between a truth or a lie, or the importance, of an oath, and that we need to be telling the truth in court, that may be something that the court would consider. And if a child says, I like being at dad's house because I get to stay up late at night and watch cartoons, well, maybe their preference isn't well reasoned. And so it's important. I'm newer to doing this as a judge, but I was a guardian ad litem. And one thing I found is sometimes you have to read between the lines because children are pressured. And you have to listen carefully and pick up on cues, and it's hard to build that rapport as the judge in a shorter amount of time. So it's optimal to have a guardian ad litem, but unfortunately, the parents have to be able to afford that. So the guardian ad litem can help get some information that's helpful to the court in reaching all these factors.
Yeah, one thing I always tell my clients about a child testifying or a child talking to the judge is that there are still all the other factors. That's just one factor.
Exactly.
And, judges don't like to let the children make their custody determinations.
That's a great point. And there's if you want to search online, the Pennsylvania Bar Association did a great video on the court talking to the children, and you can hear from some good judges in Pennsylvania, including our administrative judge, Judge Kim Eaton. There's some other judges from all around the state that talk about their different ways of talking to the child and about their preference. And so they have different styles, but it gives you a sense of what that might be like to have a child come to court and talk to the judge. And typically, you don't want the child being recalled as a witness and badgered. So there's ways that judges go about trying to make sure that doesn't happen.
You say that.
Oh, sorry, Debbie.
We have a question.
Yeah, I do have a question. You said that the guardian ad litem costs money.
Yes.
So how is it, but if the parties really are at odds with each other, and the child is suffering, right, it's a young child, I mean, is there, are there organizations that can help with this?
That
Or
is an excellent
is there
question.
social work organization?
Right. So the question was, because it costs money and a child may be at risk and we're not getting to the best interest of the child if the parents can't afford it, and those are oftentimes the cases that they need help, what are the organizations that can help? So what I have started doing is there's a group called Court Appointed Special Advocates, and they are nationwide, but Allegheny County has one. I know Washington County utilizes them and a couple of other local counties, and they do more work in dependency court, but they have offered to do some custody work. And so I just actually had a conciliation yesterday where there's a child who has all these medical needs. The medical needs are tied in with co-occurring psychological needs, and the parents need help. And the court-appointed special advocates went to the school, they talked to the doctors, they gathered information that the court can't go out and do. If the people don't have attorneys, and attorneys are limited because you as an attorney you're not going to talk to maybe all of the child's therapists and maybe the opposing party's therapists. The court-appointed special advocate can do that. I'm very thrilled with the result so far because that's important information. You have to, it's so important for a child of the ages of between, maybe 5 and 7, and they're suffering in this way, and the parents are struggling. They both love the child, but they get caught up in their battle, and they may have their own challenges. So that's one resource. I will tell you, custody court needs more. So if anybody has a plan to get some funding, we need more resources because if you're in dependency, you're going to have all kinds of services. Do you have anything to add to that, Morgan?
No, I don't think so.
Okay, so speaking of which, we're going to talk about dependency court a little bit. So we talked about the fact that dependency court is when Children, Youth, and Services gets involved. And you probably have seen this in TV shows where there's an allegation that maybe a parent's on drugs and the child's you've seen this on the news, a child's walking in a diaper in McKeesport. So I had the opportunity, and I think of it as a privilege. It was it was difficult to be the on-call judge to hear these calls in the middle of the night. And because sometimes the caseworkers need to make emergency decisions, and sometimes they need to remove a child. Not all of these calls end up in a removal, but they would be removing a child after speaking with a judge on the phone and getting authorization verbally. But that follows up with having a hearing. But the kind of things, the standard we're looking at is, in these cases is, every parent needs to have a minimum standard of care for a child's physical, intellectual, and moral well-being. So some of the cases that I've handled as a parent advocate is there's not proper parental care and control. A child isn't getting to school. The child isn't getting homework finished. A child isn't getting dental. And it could be more serious in neglect where the children are unsupervised, the parent is on drugs, the house is not in a clean condition, there's not food, there's not gas, there's not electricity. Sometimes with teenagers, it's under the statute, there's a section for habitual disobedience. So you could have perfectly appropriate parents, but the child may have mental health issues, other co-occurring disorders, and they're going out, they're running away, they have oppositional defiant. So it's a very nuanced area, and it's a very high standard. This is one of the areas in the law where, in civil law, where it's a clear and convincing standard of evidence. It's under, a little bit under, you've all heard of reasonable doubt. But clear and convincing is a high standard because you're you could be removing someone's child. Ultimately, you could be terminating somebody's parental rights, and we'll get to how that happens. But you do have a right to an attorney, and in Allegheny County, we have parent advocates. The children get attorney through Kids Voice. We have conflicts attorneys if there's several fathers, and we have a ethical conflict. So there are a lot of resources here to help the parent. Now, procedurally, I told you about those emergency custody authorizations, and then you have to have a shelter care hearing within 72 hours. If for some reason it's denied and there's no removal of the child, there's some different time frames. But after you have the shelter care hearing to determine if the child was appropriately removed, then the agency has to kind of back up what they told the judge to either a hearing officer or a judge. In Allegheny County, the judges, I think, hear the shelter hearings. But once they prove whatever they've said, then you have to have an adjudication hearing, and that's a serious hearing. And that is, they call it a petition hearing oftentimes, and that, there's no hearsay. There's a lot of places in dependency court where you could have, oh, the teacher told me, or the neighbors saw this. In an adjudication hearing, it's like a trial. There is no jury, but it is very important. You may have experts from Children's Hospital if there was physical abuse, sexual abuse, and it can be very weighty. And then after there's an adjudication, there's review hearings, and typically the court needs to see the child. The review hearings are supposed to happen every 6 months, but they typically, most counties, best practices, we are doing it every 3 months. And this was all adopted through the federal Safe Families Adoption Act, Safe Families Act, because there were horror stories in the past of cases that happened and the child was no longer living. And the court didn't see the child. So it's very important that the court sees the child. Morgan, do you have anything to add? Because I did go through quite a bit there.
I don't think so. I don't do a lot of dependency work in my practice, but I know that it's very serious.
Right.
Yeah.
And so in custody cases, the overlap is sometimes the parents will both say, they're a horrible parent, they are on drugs, they're alcoholic, and then you have to think, well, if you're both horrible, then maybe we need to get this in dependency court. And there is some overlap there where we do see families who've had dependency cases, and they've been through protection from abuse cases as well. One of the things on the chart I would like to stress is that if a child has been out of care, so let's say that the child was removed, they were put with, and it's best practice to put with a kin. It doesn't have to be blood relative. It could be a very good family friend. But the courts are moving towards making sure that the child remains within their support systems and that we use resources. And so if the child's out of your care for 15 out of the last 22 months, the goal in your case could be reunification is the primary goal, but adoption could be the secondary goal. And if you don't, as a parent, meet all of your requirements, and it can be tricky, to make sure you're going to drug and alcohol treatment, getting mental health treatment, proving that to the court, not testing positive for drug tests, going to drug tests. If you don't get that all together within the time frame, your rights can be terminated. And I will tell you, the Supreme Court has called termination of parental rights the death penalty of family law. So it is very serious. There is a lot of litigation going on about that, and I'll have Morgan speak a little bit about a case she just looked at as it related to the overlap of dependency, the termination case. If you don't want to speak to that, that's fine.
Which case was it?
The termination of parental rights case that the mother wanted her parents to adopt, but it wasn't. That was a private adoption.
Yes. Yes, the mother wanted the parents to adopt because Okay,
Are
we
out
are
of
out
time?
of time,
Oh,
so
wow.
we'll skip that. We'll skip that one.
So, let's see, how do we wrap this up? Are there questions on what we've talked about? No questions? Well, one thing that we've proved true is that lawyers can talk. My kids tell me all the time, Mom, you could talk.
Yep.
So,
Information that you convey.
right.
Yes.
So, if there are no questions, Deb, did you want to give our parting remarks? She's coming up, on her way up here.
Okay, so I want to thank both of you very much for joining us. We will be circulating a copy of in PDF of the slideshow so that you can have it. I also didn't give a caution at the beginning, but we can't be giving legal advice. We just are educating you about family law topics. If you want more information, we can give you resources to help you, and thank you and have a great evening.
Thank you for
Yes,
joining us.
thank you, everyone.